Welcome to this unusual edition of the Technology Pill. Today we come to you with news about Clearview from the UK Data and Privacy Regulator, the Information Commissioner's Office. Don't worry, we're still a podcast that looks at how technology is reshaping our lives every day and exploring the different ways that governments and companies use tech to increase their power. My name is Gus Hossain, and I'm the Executive Director of Privacy International.
My name is Caitlin Bishop, and I'm Privacy International's Campaigns Officer.
And here to talk about the week we've had, we're joined by Lucie Audibert, who you may remember from our summer reading podcast, to discuss all the latest news of this week.
So Lucie, do you want to start us off with a description of what news we're talking about?
Yeah, of course. So on Monday this week, the ICO, which is the UK Data and Privacy Regulator, announced its provisional intent to impose a potential fine of £17 million on Clearview AI, and more importantly, a provisional notice to stop further processing of personal data of people in the UK and to delete the data. So that's a lot of conditional terminology, unfortunately, because it's not a final decision, but it's still a huge and excellent result in our fight against Clearview AI, the facial recognition company that scrapes photos from the internet and builds a gigantic biometrics database.
Facial recognition companies are a dime a dozen now, particularly the rise of China's tech industry in this sector and others. What was it about Clearview AI that made it such a key actor for us to go after?
So Clearview AI, in our view, was the epitome of how you can use new technologies wrongly and in a way that affects people's rights and privacy. What Clearview AI does, it collects every single photo that it finds online, which means your face could have been grabbed by Clearview AI and filed in its gigantic database, whose access it then sells to government agencies or police forces around the world. In our view, this was exactly the kind of thing that European data privacy laws were designed to prevent. And we're really glad that finally, after almost 2 years of knowing about Clearview AI, regulators are starting to take steps to stop these practices.
And why did the ICO take this step now?
So the ICO opened an investigation to Clearview AI last year in 2020, but it took a long time until we heard anything about this investigation. And we were concerned that no other European regulator was taking action. So in May this year, we decided to file coordinated complaints across Europe with various data privacy regulators in order to wake them up and say, look, Clearview AI is, in our opinion, violating the most advanced and protective data privacy laws in the world, and you're not doing anything. And so, 6 months onwards, we have the first decision that came out from the ICO, and it's a really good one. So we really hope other regulators follow suit.
There's some beautifully, you're such a good lawyer, because there's some words in there you threw in your descriptions that intimated how this is hard. That is, to us non-lawyers out there, we have to understand that the law is not self-actuating. Just because there's a law like GDPR doesn't mean that companies will immediately comply. And even if there is a problem, it doesn't mean regulators will immediately jump forward. These regulators often need spurring. And I recall when we heard that the UK regulator was acting on this, it wasn't. Well, I can say this because I've been around long enough. It wasn't exactly a sigh of relief to hear, the UK regulator's on it. Just as when we heard that the Australian regulator was on it, we didn't breathe a sigh of relief because those are two notoriously weak and slow regulators. And the Australian regulator, as much as it can look into things, it doesn't actually have fining powers. And so, that's why I was excited when you all at PI decided to spur other regulators into action. And so can you describe what it was that got these regulators, or how we're trying to spur these regulators into action so that they do take Clearview seriously, or in the UK regulators' perspective, did take Clearview seriously?
Yeah, so we're using the GDPR in the way that it was intended to protect people. The complaints we filed are based on what we call data subject access requests that we filed with Clearview. and that show that some PI members of staff had their photos in Clearview's database. And so in that sense, we had what can be called a right of action against Clearview, because we knew that they were processing our personal data. And in that sense, we went to regulators to say, look, whatever action you take will not be just action in a vacuum. It will be action against a real processing of personal data. And so, yeah, and the idea to have a coordinated complaint as well was so that we wanted to show that Clearview's business model is simply unviable, despite it claiming that it's based in the US and that it doesn't operate in other countries anymore. What they were doing was blatantly violating European privacy laws, and that's what we wanted. We wanted regulators to stand up and say. The preliminary findings that have been published by the ICO are pretty much a copy-paste of what we said in our complaints. All of the arguments that we put forward, the ICO has agreed with them. How much we influenced them in that decision, we can't possibly say, but we know they agreed with us, which is already a huge thing. So what the ICO found, in short, is, first of all, that Clearview can't escape European data protection laws. In that sense, the ICO said, we have jurisdiction over you, and you will comply with our laws. It found that Clearview has no lawful reason to process people's data in the way they did. It found that it was wrong not to tell people that they were scraping their photos. And it found that it wasn't fair to collect your data in a way that you can't possibly expect. So that hits all the kind of key points in data protection law, and we very much welcome these findings.
Nice. What happens next? Like, the ICO have made all these provisional judgments. What happens next?
So yeah, as I said, this is not a final decision, and now Clearview has the opportunity to make representations to the ICO, so effectively tell the ICO why it disagrees and why its technology is not as dangerous as we say, etc. And then the ICO will take a final decision that's expected in mid-2022. So in that sense, we're obviously a bit disappointed that the decision wasn't more forceful, but it's already a great result, and it's the kinds of steps that a regulator has to take. Clearview has actually already stated that they intend to appeal or take further action to challenge the preliminary breach findings. And we know from press reports that they have hired UK lawyers, so it looks like they're intending to fight this in UK courts and to submit to UK jurisdiction. So it means this will likely go to court, and it means the fight isn't over. So we'll be there.
And what about other regulators?
So we're still waiting on other regulators to take action. We're waiting on the French, Italian, Greek, and Austrian regulators. We hope this decision will inspire them to take the same, to make the same kind of findings about breaches of GDPR, because they're relying on effectively the same law as the UK is. So there's no reason why they shouldn't find the same things. There's obviously a big question mark as to enforcement of all of this. As I said before, Clearview is based in the US. So it will be up to regulators to fully apply their enforcement powers, and to courts in European countries to apply these decisions, and to Clearview as well to decide to live up to its reputation and actually realize that its business model is just not viable.
Yeah, and you keep on repeating that because it matters. That is, it's not a viable business model. We've had regulators say as much, and the fact that Clearview is currently still relying on investment money to survive. A 17 million pound fine hovering over their heads does not create a hospitable fundraising environment for them. So I think that this, no matter how long the appeal takes, it will still be hanging over their heads. And no matter how long the other regulators take, and to be fair, regulators take a long time to come up with their decisions. The fact that we have two regulators now, being the Australians and the UK regulator, coming out against Clearview, this does create a bad environment to be a intransigent facial recognition company that uses data from the internet.
And from a technological perspective, if Clearview actually applies the decisions and deletes the data it was asked to delete, then its whole product falls apart, because it relies on indiscriminately scraping photos off the internet. And when it does that, there's just no way for it to decide whether a photo is from a UK person or from a US person or from a Greek person. So it will have to recognize and say to its investors that its business model just cannot comply with the regulators' findings in so many countries around the world. So that's huge.
And America has to wake up and recognize it needs to do something here.
A federal privacy law.
Yeah.
What does this mean for Clearview's algorithm? Clearview's trained their algorithm on the basis of the data they've already collected. The data they've already collected includes UK people's data that even if they delete the data from now on and don't process that data from now on, they've already trained their algorithm on it and they're gaining, competitive advantage and money off the back of it. Like, does the ICO judgment have any, impact on that?
Yeah. So I think regulators are not forward-looking enough and not technologically savvy enough to even think about these things. So the decision itself doesn't require. I was going to say Facebook. My God, the ICO decision itself doesn't require Clearview to restart training its algorithms based on data that doesn't include UK people's data. But you're right that in practice, if it were to fully, if the decision were to have its full effect, its full intended effect of protecting people and giving remedy to people, it would require Clearview's algorithms to be retrained and go from a blank page with only the data that it's allowed to process.
And then, of course, we've got however many judgments coming up, hopefully, that may cover that.
So the fight's not over. We know we can win this, but success so often depends on being able to fight over a long period of time. So, for example, one court case that we won this year in the Grand Chamber of the European Court of Human Rights that was all about the UK government's mass surveillance regime and how it violated privacy, of course, and freedom of expression. That one case took 8 years and the combined resources of 16 non-governmental organizations and activists. I know for a fact that at least 7 children were born among the lawyers involved in the case in that period of time. This is why this type of advocacy is so hard. But as you can see from an example like the one we're covering today, and from that European Court of Human Rights case that we covered earlier this year, these decisions have meaning and they have value.
Whereas for-profit businesses like Clearview can spend a lot of money defending themselves in court for years. In fact, since our legal challenge, they have raised $30 million in Series B funding. We don't have that kind of money. Can you chip in to support our work? If you can, find out how at pvcy.org/donate-pill, or you can go to our website and you can click the big donate button. Whether you can or not, we appreciate you. Thank you very much for listening. You can like and subscribe to the podcast on whichever platform you use, and it's also available on our website. Music courtesy of Sepia.
You say sepia, I say sepia, okay.
We've had an argument about this before because I was convinced that sepia is wrong, and Max, who actually knows sepia, was like, no, it's fine. And I was like, I don't understand. Surely the way I say it, surely the only way I say it can be the only true way to say it. But turns out no. And the world is bigger and all that jazz.
Cool.